So thank you for coming today. We'll build it up again. And even you can even come early at 11:30, bring your lunch, socialize a little bit beforehand. Today, our topic is the Kansas Supreme Court selection process. And we have two really, I think, excellent speakers. If I don't say so myself, I'm the one that contacted them. But we have Gloria Farah-Flemke.
Not to prove you wrong.
You are. She is the current chairperson of the Supreme Court Nominating Commission. This is her second term. Her first term was as the 4th District representative on that commission, but now she's been elected by her peers on the bar to serve as the chairwoman of that committee. So it's really a completely different role on the commission, a different term. And she can tell you about how it works and so forth and so on. I don't need to explain that. We can do that, or Susan can. And then Gloria is going to tell us why we should keep the current system. She'll explain all about that system, how it came about, and all that stuff. Representative Susan Humphreys is here to tell us that there is a move afoot to change the system to a different way. And she can explain the different way and why it would be important for Kansas to do that. I think each person sounds like he got about 10 or 15 minutes worth of stuff to tell us. We'll allow for a short little rebuttal if either of our speakers would care to have it. And then we want to answer questions from you. Representative Humphreys has got a time squeeze today, so she's going to try to leave a few minutes before 1. So if you have a question for her, we'll try to get that in first in our Q&A session so she can get to her appointment a little bit across 10 minutes. So, at the end, the library asks us to fill out this pink half sheet of paper. It's kind of a little evaluation of today's program and asks for ideas. It's real simple and easy, and it doesn't require your name unless you want to be contacted in the future about library events, which is good to have, actually, because they do a lot of interesting stuff here at the Advanced Learning Library. So, I'll get out of the way and let our speakers speak. Let me first turn it over to Gloria Farah-Flemke. She's the current chairwoman of the Supreme Court Nominating Commission. Before she retired, she's a lawyer and worked at Boeing for 5 years and Spirit for 6 in the administration at Boeing and Spirit.
On general counsel.
General
At
counsel.
Spirit and chief counsel of Boeing. Then did some other things.
Oh.
And I practiced law for over 40 years.
Oh, gosh, before that.
Yeah.
Wow.
Yeah, I practiced law as a private practice in Wichita for 20 years.
Well, great. So we got a great.
You're stuck with me, sorry.
Thank you for being here today. And we're going to try to do this without a microphone, but if you can't hear, let us know because we do have microphones available.
Well, I'm not going to use that podium because there's a great big screen there and I wouldn't be able to see you all and
Okay.
you'll wonder who I was. So it's nice to be here. I'm sorry there aren't more people here, but I promise that Representative Humphreys and I are not going to have fisticuffs or anything. This is not like the old days. I see a few people who might remember the Tuesday night fights. You all remember? I grew up in Wichita native, so I remember all those things. But I'm here to talk to you about the plan we have now and how we select the Supreme Court justices. And I want to start out by saying, how did we get to the way we select Supreme Court justices? We started out, what we have now is what we call a merit system selection process. We hope we find the best lawyers who want to be a Supreme Court justice. We interview them, we pick the top 3, and we send their names to the governor, and the governor makes the selection. That's the shortened version, but let me tell you a lot more about it. It all started a long time ago. I remember, regrettably, But in 1956, in the Republican primary, the sitting governor, Fred Hall, got beat. He was very upset about it. And the person who beat him, a gentleman by the name of Warren Shaw, who I do not remember. I have to say, I remember Fred Hall, but I do not remember Warren Shaw. In those days, we elected governors every 2 years. And the reason we don't remember Mr. Shaw is because he got beat by George Docking. So he was never governor. But after George Docking got elected, the Chief Justice of the Kansas Supreme Court became ill, and he resigned. This is called the triple play in history. In fact, if you look up the triple play, there's some blurbs about it online. But, so what Governor Hall, sitting in his office thinking, my term is about up, what should I do? Oh, I would like to be on the Supreme Court. He resigned from the governorship. His lieutenant governor became governor and served as governor for 11 days. And in those 11 days, he appointed Governor Hall to be on the Supreme Court. Now, this was all legal. You couldn't go to court and say, foul, foul, but everybody thought there was a foul. And the Kansas legislature especially thought there was a foul. And so in the next session of the legislature said, we're going to change this process. And they did an investigation and looked at how the best way to do it, and they decided what they really wanted to do was have a merit selection process. One that's been used in other states. Some people have called it the Missouri plan, although I don't think Missouri has it, but anyway, that's what it's called. And they set up a system. They decided to have a constitutional amendment to change how Supreme Court justices are appointed. And so they had the bare bones of how that was going to happen. They passed a proposed constitutional amendment, and then it went to the voters in the next general election in 1958, and the voters said, yes, this is how we want to select our Supreme Court justices, and that's how we've been doing it ever since. At that time, we did not have a Court of Appeals, so there was no mention of the Court of Appeals in there. I think if we had one, it would have been in the same constitutional amendment, but it didn't exist. So the Court of Appeals is all statutory. Well, the Supreme Court is constitutional, and that's the difference. So, here we have this process, and how does it work? I mean, I don't know how many people really understand how it works, so maybe I'll give you a little summary of how this all happens. And most of it, what the constitutional amendment said was that candidates for the Supreme Court will be selected by a Supreme Court Nominating Commission, which will be composed of representatives from each of the congressional districts, a lawyer from each congressional district, and a layperson from each congressional district. The lawyers will be elected by the lawyers of the state. So that now we have 4 congressional districts, because this has changed. At one point we had 5 under this. So in the 4 congressional districts, lawyers run to be on the Supreme Court Nominating Commission, and the lawyers in that district vote. And then the lay people are appointed by the governor. There is one more person, and that's the chair. And the chair is elected statewide by the lawyers. And that's all set out in the Constitution. All of the more detailed things the Constitution says will be determined by the legislature. So the legislature's passed a number of laws about the process and things that the nominating commission has to do. So that all filters out. And these offices are 4-year terms, according to the statute, and they They are, they don't all run at the same time, they don't all happen at the same time. And anybody who is on the Supreme Court Nominating Commission can serve 2 terms, which would be they're 4-year terms, so that'd be 8 years total. When you're on the Supreme Court Nominating Commission, you can't do anything else political. You can't serve on a politically appointed committee. You can't run for office. You can't apply to be a Supreme Court justice. In fact, lawyers have to wait at least 6 months after they go off the the Supreme Court Nominating Commission before they would ever apply to be on the Supreme Court. The whole goal was to have a way to pick the people who are the most qualified candidates. And they would pick 3 candidates and then send those to the governor. The governor would interview, and he or she would then make the appointment. And that's what we've been doing since 1958. Some people want to change that, and I think we'll hear from Representative Humphreys what she thinks we ought to be doing. But I have to tell you, I think this system works. I want to tell you a little bit about what we do as a Supreme Court Nominating Commission. I have some notes here, and I think I've gone way somewhere. But what we do, if there's a vacancy, immediately out the office of the Supreme Court, the clerk of the court sends a notice to all attorneys in the state of Kansas and said, there's a vacancy on the Supreme Court. Here's how you apply if you're interested. We encourage you to find people who are qualified and would be good candidates. And so that's how it starts. And the interesting thing about it is that generally, if a Supreme Court justice is going to retire, he or she lets people know, I'm going to retire effective January. We at the Supreme Court Nominating Commission like that, because that gives us a little more time. Because if they decide, walk in and say, I've had it, I'm gone today, we have 60 days to get 3 names to the governor. And we're pretty diligent, I want you to know. We spend a lot of time. First, we put this notice out. Then we get applications from people, and the application form is very detailed. People tell everything about their history. We also have background checks on everybody who applies. We also look at their social media. We have someone do it. We don't do it personally. We have someone do that. Because we want to know who these candidates are and want to make sure that they don't have something in their history that people would look to and say, this person shouldn't be a judge. So that happens. We get the applications, and I went on a Supreme Court Nominating Commission 6 years ago as the 4th District representative. And for the first 3 years I was on, there were no vacancies and we did nothing, okay? I thought, wow, I'm gonna get through this, I'll never have a job. And then, bang, 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 there were 3 vacancies. And so we spent a lot of time, and the applicants, we had about 19 applicants for every vacancy. That's a lot of people. And we made the commitment that we would interview every candidate. We would research every candidate and make sure we knew everything we needed to know about the candidates. So we spent quite a bit of time. And the way we did it is we divided up the candidates. Everybody read everyone's applications, but everybody didn't go do an investigation on 19 applicants. We split them up, and because we're going to do detailed investigation. People list references. We called all the references, interviewed the references. We called at least 3 other people, sometimes many more, who would know that attorney to find out what they knew about the attorney, what they thought of that person, and would they make a good judge. Now, sometimes the applicants are judges, but we still do the same investigation. A district court judge may apply, or a court of appeals judge may apply. But there are a number of candidates who are practicing attorneys. They have to be 30 years of age or older, and they have to have practiced law, served as a professor of law, or been a judge for at least 10 years. to be qualified to be on the Supreme Court. We also have a duty to encourage people to apply if we think there are good candidates out there. And I have to tell you, representatives, this is for you especially, we would have more applicants, in all honesty, and would have a wider variety of applicants if we paid our justices more. They are paid, I think they are next to the last in the United States.
We raised it last year.
Did we, are not next to last anymore? Oh, maybe next to the next to last. But anyway, it's a hard decision for an attorney who feels the call and feels, I have a duty, I believe in the law and I want to serve the law, to decide to go on the court. Because almost all of them take a cut in pay. It's very difficult, and we want people who want to serve. We don't want people who say, well, I haven't done a very good job of practicing law, and I don't have very much money, so maybe I'll apply for the court. That's not who we want to serve. We want good candidates. So, I hope you all will keep thinking about raising those salaries, okay? I've got other things I want you to spend money on. But that one's very important to me. I have been committed through my whole career in supporting an independent, a free and independent judicial system. It's what makes the United States work. So we have judges who are independent, who look at the law, who look at the facts, and make a decision based on what they have in front of them. Not because their good friend Harry said, you ought to go do this, or because, I used to be a Republican, or I used to be a Democrat, an active Republican or Democrat. They continued to be their party. They don't change. They don't have to give up the party. But so the people I want to appoint are all going to be part of my party. That's not what we want. We want lawyers who are committed to the law, who are going to do a good job. And I think we've been quite successful at getting people on the bench who do that. And I am responsible partially for 3 of them, but not for all of them. But I think, I think all the justices have done a very good job. Now, the legislature thought that this ought to be an open meeting event. So they, in the statutes that they passed about the nominating commission, they said that we have to do everything in open meeting. Deliberations, everything. If any of you served on a school board, and I represented school boards when I was in private practice, you talk about all these things, you do it, and then you go into executive session and you have, especially when it's talking about an individual, like a teacher or somebody, and you have confidential discussions. We can't do that. The only thing we can do in executive session, and let me find the words, is discuss sensitive financial information contained within the personal financial records or official background check of a candidate. We can talk about those in executive session. Otherwise, everything is in public. And I have to tell you, I knew Governor Bob Bennett, who was a good lawyer and I think a good governor when he served as governor of Kansas. And he told me one time, he said, the worst job I have is appointing people to be judges. And I said, what are you talking about, government? He said, because you make one friend and 2 enemies. Because they always get 3 names. And he was a very active practicing lawyer, so he knew most of the people whose names were coming up, and he had to choose among the people he knew, which was hard for him. So, but that's done in private, that part. We do it all in public. We vote in public. Every vote, and we do, the way we have done it, because we've had so many candidates, is we have rounds of voting, so we get the numbers down, until finally we end up with a consensus of 3 people. And then we send those 3 names to the governor. I think it is a very effective system. I think it's worked quite well. I think it helps keep politics out of the court. And I don't know, everybody may not agree with me. The court reads the law and reads reads the Constitution, and they make their decision based on that and the facts before them. I don't always agree with them, but I know that they are doing the best they can with the information that is given to them. Sometimes the lawyers presenting the evidence don't give them the right information, so that they can't step outside of that and research it and decide. And I have to tell you, a number of years ago, I was fortunate enough to be forwarded, my name was forwarded by our two U.S. senators, Bob Dole and Nancy Kassebaum, to be on the federal district court. And I went back to Washington and had an interview. In fact, I went twice. The second time I went, I sat down with a number of people, and in fact, I even was interviewed by Bill Barr, who was an assistant attorney general at that time, he wasn't attorney general. And George Bush I was president. But the attorney general's right-hand man sat down with me for an hour and a half and talked about how, the whole process and how I shouldn't complain if I didn't get the job. So I'm sitting there thinking, he's telling me I'm not getting the job. This is great. And he said, but when we appoint judges, especially the district court, when we appoint judges, we know less about them and spend less time with them than we do when we interview and hire a janitor. That's what he said to me. Very. I don't like that kind of system. I like a system that is full of merit. Now, there's still politics, and there's politics in everything we do. But I think it is the best system to get the best candidates to the governor for appointment to the Kansas Supreme Court. And I want to have the best people we can find on our court.
Thank you, Gloria. A good explanation for it. Now, Representative Humphreys, I want to present to you. She'll tell us the idea that's percolated up about changing and why that's a good idea. Representative Humphreys represents east side of Sedgwick County and part of Butler County, Andover area generally. And this year she's running for her 4th term to the Kansas House. And she's running unopposed, so that gives her a little bit of time so she can spend
I hope it turns out
Tuesday
okay.
morning with. So thank you for taking the time and for telling us the change that's afoot and the good side of that.
Yeah, so thank you all for being here, and thanks to the library for having us and the League of Women Voters. Really appreciate it. That was super helpful, the history, and I really appreciated it. And the first thing I want to say is I think the selection committee does, I so appreciate the work that they do. And I'm going to tell you what I think would be a better system, but it's not to say that I don't think those 9 people on that selection committee do not work hard and do not do the best that they can possibly do. And I think that's true. So, Gloria talked, is it okay if I say Gloria?
Sure,
yes, okay.
Please.
She talked about the triple play, which was, really scandalous back in 1957. And we all agreed that something needed to change. And so what changed was the Constitution, as we just heard. And I think it swung from the governor appointing Supreme Court justices away. It swung so far to the other side that it swung to another extreme, is what I would say. So I'm going to say that I feel like we now 1/3 of our government, one of our 3 branches of government, is controlled in Kansas by a very small group, the Kansas Bar Association. And I have a few points. One of them is I think our current system is anti-democratic. I think it's extreme, and I do think it's political. And then I'll mention what I think the solution would be. So those are kind of what my points are. Currently, no one can, and also I have monovision. I don't know if y'all know what that is, but like one eye is for close and one eye is for far. And so like this just doesn't work. So I'm gonna have to hold this in front of me since we don't have the podium. No one can become a justice on the Supreme Court without being one of 3 finalists chosen by the Kansas Supreme Court Nominating Commission. The commission is a gatekeeper to the Kansas Supreme Court. However, I feel like the commission is selected in a shockingly undemocratic way. There's about almost 3 million people in Kansas, and that commission is decided by about 5,000 eligible people. The current system concentrates tremendous power in a small group, and it actually treats other people like second-class citizens. I don't feel like in a democracy a lawyer's vote should be worth more than another citizen's vote. Less than 1% of Kansans control the selection of our highest court. Simply because of my choice of profession, I'm an attorney, I think you mentioned that, I can't remember. I mostly just do adoption laws, kind of what my part-time attorney piece is. I have hundreds and sometimes thousands of the voting power of most Kansans when it comes to electing the members of the Supreme Court Nominating Commission. And they control and limit the pool of 3 candidates that the governor has. The disparity is exacerbated by the fact that as an attorney, every 4 years, I get to vote in 3 ways on someone on that commission. I get to vote for District 4, who's going to be the Bar Association in District 4, who's going to be the overall chairman of the nominating commission for the state, and then also get to vote for the governor, which all of you do too, but you don't get those other 2 votes. So I get 3 votes as an attorney on who's going to be on that selection committee. And it's further exacerbated by the fact that only 20 to 30% of eligible attorneys even vote in that election. For example, in 2021, there were 1,498 attorneys that voted for the statewide chair to be the attorney, to be the selection, and I did vote. And so that's about 1,500 people voted for this huge job when there's almost 3 million Kansans. I feel like the current system is unnecessarily closed and is dominated by the bar. And it's not to say that the opinions of the Kansas Bar Association shouldn't be considered. Of course they should. But not dominant the way that they're dominant. The important question for democratic legitimacy is not whether the member of the commission is an attorney, but really who selects that commission. And right now, the Kansas Bar Association selects 5 of the 9 people that are on that selection committee. Which brings me to the second point, which is that Kansas is extreme in this. The Kansas judicial selection process is an outlier among all 50 states. We are the only state that does it the way we do it, that the Bar Association dominates that selection process. Other states have a selection process, they have a commission, but they're not the majority of the commission as we are in Kansas. No other state allows a majority of attorney-elected attorneys to control the nominating process of the Supreme Court. So again, we're the only state. None of the other 48 states do it this way. 14 states do it the way, like the federal system, which is the governor appoints and then the Senate confirms. 22 or 23 states, depending on how you categorize them, they vote for their Supreme Court justices. Some states it's a partisan election and some states it's nonpartisan. So that's about 22 or 23. And then a few other states have a nominating commission, and that would be Missouri. That's where we got that Missouri plan. But they don't have the majority of their nominating commission is not decided by their Bar Association. We're the only one that does it that way. I feel like, one special interest trade group controls the selection of an entire branch of government. And it's extreme. And you know, in other areas, like doctors don't decide who's going to be only on the Board of Healing Art, and only accountants don't decide who's going to be on the Board of Accountancy. Those are, some of them, and I'll mention some of these in a minute, but some of them are, again, the governor appoints and they have to be approved by the Senate. And then again, we mentioned, Gloria mentioned that they call this the merit system. And I feel like, we may call it a merit system, but the group is a powerful, they're a powerful gatekeeper to 1/3 of our state government. And it's all the way from the recruitment to the screening to the final selection and the appointment. And there's no data that says that this merit system, the way we do it, results in better, more fair, more, I don't know what you call it, judicially prudent decisions. There's no data that shows that this is actually a merit system. Because we know Kansas lawyers, as we all do, have a political bias and ideology, and that brings me to my third point. And that is that our current system is political. I mean, we can't get away from it. We're not going to pretend that politics and campaigning are not part of this process. As a licensed attorney, as a member of the Kansas Bar Association, I frequently receive campaign letters to me by a candidate that wants to be elected to the selection committee. So maybe those politics are more subtle than those present, like in a campaign for the legislature, but they do exist. And I'll give you an example that, activists can sometimes prefer state government or filing something in the state court rather than the federal court, because the state court is going to be more ideological aligned to whatever they want to happen. An example of this is in the legislature this year, we've had redistricting. Every 10 years we have redistricting. And we redistrict our 4 congressional districts. So this is a federal decision. These are our 4 congressmen and women who are going to Washington. And as we're doing it, we're back and forth and we're voting and, we come up with a map and we vote on the map. And there's some people that we know are unhappy with the map. We think there's probably going to be a court case filed. Well, you would think, and it has always been in the past, that court case, it has to do with our federal election of our congressman, has always been filed in federal court. This year it was filed in state court, which was a shock pretty much to everybody. But it was filed in state court because the system we have now is political. We don't want to admit that maybe, or, but we shouldn't say that it's not political, because that happened even this year, that people shop what court they're going to file suits in. So that was the federal question, but again, it was filed in state court. Someone's values are at play here, and we just have to admit that. Values are upstream to culture, which is upstream to politics, and someone's values are going to be at play here. It's not, and I don't think it's some devious plot. I just think it's those selecting the judges select people who think like they do, with judicial philosophy the same way that they have. I just think that's the way it happens. So we have a problem that our selection process is controlled by an unaccountable group, and it's naive to think that that it's devoid of politics. And so that brings me to my last point, which is what would be the answer to that? And so the solution, I think, that is the best solution is a federal model for the selection of Supreme Court justices. It's a happy medium between those 2 extremes that I talked about at the very beginning. 12 states, again, 12 to 14 states use this as a model. And it's the way our appellate court is selected here in Kansas, and that has worked out well. Those judges are very well respected in Kansas, and so it would be appointed by the governor with the consent of the Senate, or the confirmation of the Senate. It's the most transparent approach, and it has, again, produced those judges of highest caliber for our appellate court. And another reason I think it works is at both state and federal levels, we use indirect democracy, which means appointed boards and different secretaries and people are appointed by elected officials. So it's indirect. We vote for elected officials. They appoint people. That would be what this is. It's more accountable, and it's a practical reason. It gives us indirectly democratic systems to select our judges as Kansas citizens. And some of the state boards, Kansas Corporation Commission, the State Banking Board, Human Rights Commission, all of those are under that sort of system, that they're appointed by the governor and confirmed by the Senate. In short, the Senate confirmation of Kansas Supreme Court justices is a prudent reform that would move Kansas judicial selection from an extreme position to the mainstream of our country and our state. I feel like what we have now is really the politics of an elite few, and I think it would be better to have the politics of the majority. The way it would happen is the Kansas legislature puts forth a resolution that says we would like to put this on the ballot. They can say when that would be, that we're going to change the process. So it's put on the ballot, and then the people of Kansas decide if you want to have a constitutional amendment or not. So again, it's not the legislature saying, oh, we're going to change the system. Instead, it's 2/3 of the legislature necessary to even put it on the ballot for the people of Kansas to decide if they would like to change it. And so the people, again, would have the opportunity to do that. So, I feel like it's time to revisit our process and allow Kansas voters the opportunity to speak into the selection process. It would be more democratic, it would be less extreme. When selecting our state's most powerful judges, all Kansans, rather than just attorneys, should be involved in that process.
Thank you very much. Well explained. Gloria.
Yeah, I have a couple of things to say. One thing is, Representative, I wish you would say licensed attorneys and not the Kansas Bar, because the Kansas Bar Association has nothing to do with the process. You have to be licensed by the Supreme Court,
Good point.
and you have to have agreed to be.
You have to be a member of the bar, of the Kansas Bar, but it's not the Bar Association.
No, it's not the Bar
That's
Association.
a good.
That's just a minor point.
Great. She makes a great point there.
Secondly, you kind of forgot that just short of half of this commission are people who are appointed by the governor, the lay people. And they are very strong. They do not say, well, Gloria, what do you think? I want to vote how you vote. It doesn't work that way at all. They have their own opinions. They ask a lot of questions. They get very involved in the system, and they are very committed. So we have the governor's participation through those lay people. Historically, after we changed the Court of Appeals selection, you're saying it's worked very well. Well, with the last governor, he didn't even tell people who he was considered to be the Court of Appeals judge. He just all of a sudden announced, so-and-so is my candidate for the Court of Appeals, and then the Senate could look at it and confirm. Now, it works real well for the governor when the governor and the Senate are both the same party. Those people all get confirmed. It didn't happen with Governor, our current governor. And she incidentally set up a commission, her own commission, of people set up exactly like the Supreme Court Nominating Commission, which in fact used to review Court of Appeals appointees as well, until the legislature changed that. She set up a commission, and they review all the candidates, and they send 3 names to the governor. Now there's no law that says she has to do that, and the next governor can do it like Sam Brownback did it, and say, I'm gonna close the doors, I'm gonna have a couple people I'm gonna talk to, and I'm gonna appoint my cronies. That is what we don't want. Okay, that's why we have this system, so that it is transparent. Everything's done in public. Everybody knows who the candidates are. You can come watch them be interviewed if you want, and people do come to watch the interviews. The press comes, and they listen, they pay attention, and I think it does a disservice a little bit to the lawyers involved to say this is this elite group, because we're not an elite group. We haven't met since I become the chair, so I'm not chairing one of these. But I want you to know that, I know one lawyer who's on the commission only because she was on it before. Her term is overlapping. I know one because he came from Wichita, and I don't know the other lawyers who are involved in the Supreme Court nominating. It's not like, we're all getting together and making our decisions. It's not how it works. It is very open and above board. And I think it's one thing to say things are political. Everything in the world is political. It's not partisan. That's the important thing. It's not partisan. And I wanted to tell you that one of the things that we tell everybody who is on it, I can find that tab. It is. What we look for when we're trying to select a Supreme Court justice. Does the person have adequate legal ability? They have legal experience? Are they courteous and considerate? That's really important when you're sitting on the bench. The other thing that I have done in my history, because I've always been committed to the judicial system, was I served the whole time it existed on this Judicial Evaluation Commission, which was started by the legislature and then sunsetted by the legislature. And what the Judicial Evaluation Commission did was evaluate all the judges in the state of Kansas and make public all of those judges who were appointed and stand for retention, what the results were of the evaluations. So people could understand who the judges, what people who appeared in front of the judges, both lawyers and lay people and others, what they thought of them. That system went away. And after that went away, I chaired and before I went on the Supreme Court Nominating Commission, I chaired an ad hoc committee that evaluated the Supreme Court and Court of Appeals judges. We couldn't do the whole, because we had no money. We were just doing this, who stood for retention, so that people would know what attorneys think of the judges they appear before. I don't know about you, Representative, but every election, I get calls from all my friends and relatives, and they say, what judges do I vote for? Who should I retain? What is it we're taking away from you? See, everybody depends on the people who are I hate to call us experts because we're not experts, but the people who know a little more because they appear in front of them, they know what their practice is, they know what they've done, they know their personal habits, are they compatible with sitting on a bench? When we did those evaluations, we had one judge who was really a pretty effective judge, except people complained about her behavior in the courtroom. So we sent her a thing and told her, every judge got their full evaluation, and she came and appeared in front of us and said, this Judicial Evaluation Commission, said, I want to thank you. I just didn't realize how I was perceived. And it's pretty hard to go up to a judge and say, hey, I want to tell you, people don't like what you're doing. I mean, it's hard, because you got to appear in front of that judge. So I still think this is the best system. I don't think it's elitist. I think, the lay people are they just buy into this, and they work really hard, no matter which governor appoints them. They want to be a part of the system. They want to help pick good Supreme Court justices. You probably have something you want to say.
Well, I don't have much, but I agree. I've had friends that have been the lay members of that, and they do work really hard. I think my main point is just 5 out of 9 are attorneys that are elected by the other attorneys in the state. So that's
right.
And so maybe that's a change. Instead of going the full, maybe it's just that 5 out of 9, are not the way we do it now. So we do become more. So I'm going to say I don't really have any rebuttal. I appreciate what you said, and I like the fact that the governor decided that she would have a commission to help her decide the appellate court justices.
And she's nominated some really good people.
Yeah, so I think I appreciate the fact that she decided to do it that way. So I don't have any issues with that. So so I've got a few minutes. But I'd love, or both of us ask questions.
Ask her questions first, because she has to leave right away.
Well, I just have a question or a comment. First off, I have two sons that are attorneys, okay? And one of
I'm
them
sorry.
does.
I have one son and he's an attorney, so I.
And one of them does criminal law. And the only comment, I mean, he shared a lot of things with me, but anyway, the only comment he has is that this commission is made up of 5 lay people, and he finds that a little irritating because they're not in the law, they're not appearing, they're just kind of like a guy off the street. Do you ever, my question is, do other attorneys feel that way, or is he in the minority?
I have no idea, but as one who's worked with the lay people, I am very respectful of what they do. And see, half of our district court judges in this state, those of us from Sedgwick County may not be aware of that, half of our district court judges in the state are selected in the same process. It was local option when they did this, and so half of the district court judges are on a merit selection process and half are elected politically. I use the word political there because they run as Republicans and Democrats.
It's partisan, yeah.
It's partisan.
It's a partisan election.
It's a partisan election. And in my experience, the districts that have appointed judges are generally a little bit better judges. And since I don't practice a lot now, I still have my license, I'm still an attorney, but and I don't appear in Sedgwick County, I'm not afraid of getting in trouble.
Because that is the other option, is to do elections, to change our constitution instead, but I think most people like the federal system.
Oh, no, I don't. Doing elections,
It would be
you know,
tough.
in Texas, people have to raise 2, 3, 4, 5, a long time ago.
To be
$2, $3, $4, $5
elected.
million to run as a justice, and what risk is that? You have to go.
There's some, okay, I do want, just real quick, so it's 5 attorneys and 4 lay people. Yeah, so just to make
Yeah,
that.
he just doesn't like
But-
the
yeah,
lay
But
people.
every name, all the names we set up are by consensus,
Yes.
which was everybody.
Yeah, you do, it's like the white smoke coming out, right? When they choose.
But
You come up with
that's
3.
secret. Ours is
Well,
not
that's
secret.
true,
People
that's
hear us
true.
talk about
Yeah.
it, they hear us argue, they hear us say, well, I think so-and-so might be better than so-and-so.
Yeah.
And,
It
you know,
is.
there were some that had some kind of not so good things in their past, and you had to kind of be careful about how you talked about it, because, you know, you didn't want to see it on the front page of a paper, but.
Yes, sir.
So 2/3 of the House and the Senate vote to put it on the ballot.
Constitutional amendment.
Yes.
Does the governor have any?
No, and that, for a constitutional amendment, the governor doesn't play into that at all. It's just
Okay.
2/3.
We have 2 more constitutional amendments we're going to vote on in November. We
And
voted on one in Friday.
I-
2 more.
I would rather, if you guys go ahead and do this, that you do it at a general election and not have it on in a primary.
Duly noted, thank you. Yeah.
One of my questions on the federal system is, the US Supreme Court works a longer session than the Kansas Supreme Court, the Kansas legislature. We get the, federal legislature
Yes.
works a longer session
Yeah.
than the Kansas legislature. So if the, if
Yeah.
you have one of our Kansas Supreme Court get killed in a car accident on the way in June, you know, after the
Yes.
session's
Right,
done,
that is a great,
you
so,
can't do anything
yes,
until next
because if the
January.
Senate has to confirm, so there might be a special session called, which the governor can always call a special session. And the Senate can
I'd be surprised.
Yeah.
But that
Yeah,
costs
I
money.
think you too.
That what?
That costs
It
money.
does, you're right, it does, yeah, that's true. It would be short, I think it would be a 1-day thing, but, yeah,
Once you-
but that's
once you're all there,
that's a good point to bring up. I think
once you all are there, you need to do.
Other things. No.
I like people who know what they're talking about, to help select judges, because I've only spent time with a lawyer one time in my life, and you can see how old I am. And that was to make a will. We've been very fortunate. My sisters handled estate work for my parents, and my husband's brother did for it. So we just
Yeah, and I appreciate that.
I think I'm pretty smart and pretty well informed, but on the topic of people before the courts and, I hear the high profile national stuff, but, I'm pretty ignorant actually on how to get the best judge.
So we're not asking you to come up with names, but instead, you're voting on your senators.
I don't trust my senators.
Okay. That's too bad. I'm sorry to hear that. But the fact is, just like the lay people work really hard to get to know those 19 candidates, those senators would do the very same thing. And the governor also, in choosing, I mean, I don't think Sam Brownback pulled the name out of a hat, I'll be honest. You know, I think he did research. It maybe wasn't in the open. So he did his due diligence before he appointed, and then.
And that's how it happens in Washington too. You know, it's all very hush hush until.
Well, sometimes it is. I mean, we knew the 20 names that the past president was thinking about, you know. And actually, this president too. We did hear
Either names of possible people.
Yeah.
No, but that's, you know, Supreme Court, I'm talking about.
Oh, the other,
Supreme
yeah.
Court, Federal Court of Appeals, I mean, there's a lot of
Circuit
judges in
courts.
this country.
Yes, there are.
And,
Yeah.
and they make important decisions.
Just had one question. How many states did you say follow the federal procedure? Did I understand 10 to 12?
It's either 12 or 14.
That's not very many.
No, but 23 do the elections. Some of the elections are partisan and some are nonpartisan.
And
So
don't
almost
forget-
half of them have elected Supreme Court justices. 12 to 14 have the federal model, and then about 8 have the nominating commission.
Don't forget that our justices and judges who are not elected stand for retention. So you'll be voting on.
Yeah, there's always retention. And 1 year after an appointment of the Supreme Court, in the next general election, and then 6 years.
Right, we have 6 of our 7 justices up for retention elections.
That's a limitation, because we'll see a woman appointed to the 18th Judicial District here, and they stand for election, and the Republicans say, we'll find a one, and there they go.
There's a lot of good women
We've had a lot
judges
of
in certain
turnover, and losing people, on that retention vote.
Yeah.
Yes.
If somebody runs against them, that's true.
We better let.
Sorry to have to
Representative
go.
Humphreys But wow, what a great discussion. Thank you both for it. We learned a lot.
Thank you for inviting us.